Your Lordship, I beg to mention item number 10. Conducting observation on leave, sanction leave, Lordship. But this matter has become after 1 week.
Yes, ma'am.
Objection, Your Lordship.
On pre-made by the petitioner, this is matter to
1 week.
1 week.
Highly aware, Lordship.
May it please your Lordship.
Yes.
Lordship, mention item number 14 as the conducting counsel have some difficulty.
Item number 14.
Yes, Lordship.
I'm appearing on behalf of the respondent, my lord.
On pre-made by the petitioner, this is matter to 2 weeks.
Keep clear.
May I please, Your Lordship, I beg to mention item number 16. Your Lordship, my senior Mahanta is still unwell. Can this matter come after 3 weeks, Your Lordship?
16.
Yes, Your Lordship.
Who's for the petitioner?
My lord, Mr. Sibashi said, my lord. I'll inform, my lord.
I have taken
Mr.
the consent
Sebasti
of the
said.
parties.
You've taken his consent.
I'll inform him also. They have already made a mention.
Accommodation has been sought for by the respondent. Your respondent?
Number 1 and 2, Your Lordship.
Respondent number 1 and 2 on the ground of inability of the learned senior counsel to appear before this court today. The same not being objected to by the petitioner. Pre-allowed. This is matter to 2 weeks.
Similar prayer for item number 19, Your Lordship.
I'm for respondent number 3 and 4, Your Lordship.
For respondent number 2. Prayer has been made for seeking adjournment on behalf of the petitioner on the ground that the learned senior counsel is indisposed. The same not being objected to by the respondent. Prayer allowed. As prayed for, this is matter to 2 weeks.
Much obliged, Your Lordship.
My pleasure, Your Lordship. I'd like to mention item number 3 from the supplementary list. Your Honor, this matter was supposed to be listed with the connected matters with Nehu, Your Honor. So it has come separately today. So we'll...
No, today. I think they are listed today. The other connected matter.
Supplementary. Item number 3.
Yes, they are connected with item number 5, 6 in the main list. 6, 7, I believe.
So with regard to our matters, Your Honor, we are seeking some time.
On pre-made by the petitioner. Have you sought consent from the respondent?
I didn't meet them, Your Honor. Or Your Honor will take up when the matter comes. We'll have them.
Okay.
Your Honor, similar prayer for item number 11.
My lord, I'll appear for the state respondents here.
Any objection?
No, my lord.
On pre-made by the petitioner, this is matter to 2 weeks.
Your Honor, similar matter for prayer for item number 15. We are for respondent 3 to 5. I for the petitioner.
Yes, any objection?
No objection.
Prayer for accommodation has been is made on behalf of the respondent number
3 to 5.
3 to 5 on the ground of indisposition of the learned conducting counsel. Same not being objected to by the petitioner. pre-allowed. This is matter after 2 weeks.
Obliged, Your Honor.
Please, Lordship. Lordship, I beg to make a mention for item 9.
Why?
Item
I mean,
9.
this matter was supposed to be heard today.
Lordship. Lordship, I'm praying for a week's time, Lordship, because Mr. Paul is having some difficulties, Lordship, today. He's indisposed.
Who's for the petitioner?
He's
Petition, Your Lordship. No objection, Your Lordship.
Accommodation has been sought for on behalf of the respondent number
Lordship. 1 and 2, Lordship.
1 and 2 on the ground of personal difficulty of the learned conducting counsel. On preamble, the same not being objected to by the petitioner. Accommodation is genuine is hereby accorded. As prayed for, this is matter after 2 weeks.
Highly obliged.
From supplementary course list, item number 1.
Your Lordship, before going to the merits, these are those bails which were granted by the full bench also and by the Honorable Supreme Court also. So in my humble submission, Your Lordship, these are the cases already covered, and Your Lordship has passed series of bail orders also with other matters.
What is the matter about, Mr. Hungry?
Regarding the coke factory which were closed and all those people who were involved in the functioning of those coke factories.
This is okay. Undisputed bail.
Shalang PS case of 39/12/2022 under section 188, 34, 379, 120B, read with 30121 MMRD Act, read with section 15 Environment Protection, and 3 of explosive. Those are same FIR, Your Lordship.
But this see, undisputed bail matter is supposed to be moved before the full court, isn't it?
We have moved before the trial court
Then,
prior to the full bench order.
yeah.
It was
But
rejected.
subsequently, by virtue of the Supreme Court's order,
Yes, Your Lordship,
they should have been moved before the.
before the full bench.
Your Lordship, just last week I was in Makurwat. Even after, despite the orders passed by the full bench also, I mean in other cases which I've come to learn, the trial court has again rejected because he has already rejected once. That is why.
No, but what the court is saying is that you should move it before the full bench.
Because
This is
another
another
aspect is
matter.
that those who had come to the full bench was under the directions of the Supreme Court.
Exactly. So that is why I'm saying that since the
There is an order before from this bench also, Your Lordship.
since the full court has, since the Supreme Court has given direction that matters of this kind, especially undisputed bail matter, should be moved before the full court. So I think you should have approached the full court, not here.
No, Your Lordship. Those are only those who had gone to Supreme Court. Thereafter, Your Lordship has granted bail in Sumit Kumar Agarwal's case. I've just placed in Bina Marak.
Arising out
All
of
these
the
are
same,
anticipated bails.
whether it's arising out of the same PS case.
Yes, same PS
Then
case.
that can be seen.
Okay, so those matter directed by Supreme Court is only with regard to those
To those
petitioners
people,
who are-
29
who
people,
have
that
approached.
is why. So thereafter, Your Lordship, many has approached Your
So
Lordship.
the rest
and
are
Your
taking
Lordship has-
advantage of that.
That order. And Your Lordship has allowed.
Very convenient. Heard Mr. P. Nongri, counsel for the petitioner, who has submitted that the petitioner hearing will you issued a notice under 41A?
In one case we were issued, in the other case we are not issued.
We're talking about this,
First one.
This first one, yes, Your Lordship.
and you had appeared.
On 29/5/2023, we appeared on 13/6/2023.
Gunung Toko. Was deemed to be involved in connection with Shalang PS case number 39/12/2022 under sections IT section 1, and for which he was served with a notice under section 41A under bracket 1 41A CRPC under bracket 1 more too 41A 1 by DIO and for which in compliance thereto he had appeared before the said IO on 13/6/2023. However, in due course, the petitioner apprehends that the police might arrest him in connection with the said Shalang PS case, as was done in the case of other co-accused who were served with notices under section 41A and were eventually arrested. It is this apprehension of arrest that has compelled the petitioner to approach this court with this instant petition. The learned counsel has also submitted that the subject matter herein was taken note of by the where's the reference to the Supreme Court order?
This I would like to rely on this judgment, Your Lordship. Just you mean that judgment, so the one.
Honorable Supreme Court,
Paragraph 4, Lord.
in special leave petition under brackets civil number 28879/2023, wherein the Supreme Court, by order dated 7/8/2023, had directed the petitioners therein to approach the full bench of this court for prayer seeking grant of anticipatory or seeking a grant of pre-arrest bail, which was accordingly done so. The full bench of this court, on application so made by the relevant order dated 29/8/2023, has also allowed the prayer made in the said application and has granted pre-arrest bail to the petitioners therein. This the petitioner, being involved in the self-same Shalang PS case, has therefore prayed for application of the principle of parity and has hereby approached this court with prayer for grant of previous bail. Ms. Yangi, Leonard EAG, appearing for the state respondent, has no objection to the prayer made on the ground that the case of the petitioner hearing is covered by the relevant order of the Honorable Supreme Court, the full bench of this court, and also by a number of similar and identical prayer orders made by this court. Accordingly, the prayer of the petitioner is hereby allowed.
Some conditions.
Oh, definitely. We allow the in the event of his arrest, the petitioner is to be enlarged on bail on the following condition: that he shall not. I can give condition. Same condition which were given in the earlier cases. In view of the above, petition is hereby disposed of.
Item number 2.
Item number 2 also the same, but
Arises out
there's
of the
no
same.
notice.
Yes, but there is no notice under 41. And the accused person has been evading arrest all this while.
Fine, I'll pass these orders.
Your Lordship.
Same, coming along to same order. Thank you, Candidate. You answer correct, no?
41A is not here.
We just say delete that
Yes.
portion where
41A
the
is
notice.
No notice.
41 is
Item number 3.
Your Honor, Worship, can it be listed with those connected matters together with the daily list matters?
here. Come, call.
Obliged, Your Honor.
Daily costless item number 1.
Your Lordship, in this matter, we've already filed a rejoinder affidavit.
You file. The counsel for the petitioner has submitted that the rejoinder affidavit to the counter affidavit filed by the respondents has been filed. Accordingly, on pleadings, this matter is now posted for hearing. This is the matter up to 2 weeks.
Much obliged, Lordship.
Item number 2.
Your Lordship, item number 2, service is awaited, so I pray that the matter be listed after 10 days. By then it should be served.
Mr. Pinobri, counsel for the petitioner, has submitted that the report on the notice issued upon the respondents 1 and 2 has not yet been received. It is prayed that the same may be awaited. As prayed for, let the petitioner confirm due service of the notice and to file an appropriate affidavit of service in this regard. This is matter after 2 weeks.
Obliged.
Item number 3.
I was pleased to call for the CD. Number 3, sir.
No, what about the respondent number 3?
I think on the last occasion it was not called for the case diary, but it was called for the status report.
Status
No,
report.
no. What about the respondent number 3?
Our notice has been served. We have already filed an affidavit. Affidavit was filed yesterday. Affidavit was filed yesterday. Affidavit of confirmation of service. Service of notice. Second of December.
Oxo matter?
Yes, ma'am. My lord, he's in custody.
May I please, Your Lordship? Lordship, we've just received the copies of the case diary and status report. Lordship, if this matter can be listed for hearing, we can dispose it of the next day.
What is this? I mean,
Lordship, this is the bail application for the NDPS matter. Whereas
so you have the case record with you?
Yes, Lordship. You can submit a copy.
Why
Or
then?
we can submit the next date and we can
Why
finish
do
the
we
arguments.
why do we have to put off the hearing till the next date?
Lordship, this matter is being conducted by Madam N.G. Shella, Senior Government Advocate.
Doesn't matter. You are there.
Lordship.
You are also senior.
Lordship.
Isn't it so? Bail matters. More
Lordship,
often than not, it should not be. It should be taken on a priority basis.
Lordship.
So we'll hear the matter, Mr. Harwala.
Your Lordship, it can be listed, Lordship, after a few days also, because we'll also need to go through the same, Your Lordship.
Up to you. On pre-made by the parties. Is this matter after 1 week?
Item number 5.
These are my list. Two zeros.
Miss Paul she's on legs, Lordship. So I played the matter pass over for time being, Lordship.
But the fact is this, my lord, right from the beginning, the submission we are making, but this case will be taken up, my lord, after that matter which has been heard by your lordship after the judgment. That's how this matter is being adjourned from time to time, on that understanding.
Yes, because like I said, that matter is the judgment is still reserved, not likely to be to be completed within a week or so. I've got so many judgment reserve, so I have to complete those. So we'll pose it after 2 weeks then.
Lordship, as per my instruction, Lordship, pass it over for time end of the board, Lordship. It's on next week coming, Lordship. For good to respond.
Do you want to press the matter then?
Lordship.
So be it. End of the vote. Then we'll see Mr. Sen.
Item number 8.
May it please your Lordship, the conducting counsel, Dr. N. Mozika, is on legs.
There are two connected matters. One, my friend is appearing. That is item number
28.
28.
Item number 28. That's CRP number.
That is CRP number 28 of 2016.
We can start.
we can start with that.
Because the facts are basically the same in both the cases.
I would pray your Lordship if this matter may be taken up in presence of the conducting counsel.
Conducting counsel is number 2.
Yes.
We are talking about number 1. Please listen. CRP number 28. You're taking up first 28.
You are not in this case. You are not in 28.
Yes, Lordship.
Not in the last occasion. But because the question of maintainability here comes into play, so I think I'll have to start to try and satisfy the court whether this petition is maintainable or not. A little bit of the facts. We would have to go a little bit into the facts of the matter.
Yes.
So I've prepared a short list of dates. Remember? Now this application is under 227 of the Constitution, and my lord will come to the prayer made by the petitioners here, which is at page 19, 19. Before I come to the list of these.
Yes.
In the premises aforesaid, it is prayed that your lordships may be pleased to call for the records, issue a rule calling upon the respondents to show cause, and in cause or causes being shown, and after hearing the parties, be pleased to pass the following orders. Set aside and quash the entire proceedings in money suit number 24T of 2009 in the Court of the Assistant to Deputy Commissioner Shillong, since the date the matter was remanded back by this honorable court by order dated so-and-so, passed in RSA number 5 of 2016. This is their first prayer. To set aside and quash the entire proceedings in money execution case number so-and-so in the Court of the Assistant to Deputy Commissioner Shillong, since the date the matter was remanded back by this honorable court by order dated 24/2016, passed in so-and-so. Direct the respondents to refund the amount of rupees 5,27,90,248 to the petitioners during the pendency of money suit number 24T of 2009. Direct the respondent to refund the amount of rupees 4,96,06,179 to the State Sports Council of Meghalaya. To set aside and quash the modified revised decree dated 28/4/2016, passed by the Court of the Assistant to Deputy Commissioner Shillong in money suit number 24T of 2009. To set aside and quash the decree dated 27/7/2016, passed by the Court of the Assistant to Deputy Commissioner Shillong in money suit number 24T of 2009, and to direct the learned Court of the Assistant to Deputy Commissioner Shillong to start the proceedings in money suit number 24T afresh from the stage of passing of the order dated 24/2016, passed by this court in RSA number 5 of 2016, and to strictly comply with the directions of this honorable court as contained in order dated 24/2016, passed by this honorable court in RSA number 5 of 2016. Now, a cursory look at the prayers made would indicate that the petitioners here are aggrieved by the certain money execution case. But I will now come to the list of dates which I have provided. Now, the money suit was filed by me, by the respondent, way back in 2009 against the state of Meghalaya. That was for recovery of nearly 9 crores. That was in 2009. But in 2011, the suit was decreed in my favor. And in 2014, the state had filed an appeal against the decretal. The additional deputy commissioner had upheld the trial court's order. Now, 2014, the money execution case number 13T of 2014 was filed by me for execution of the decree. Then on 15/6/2015, a judgment and order passed by the additional deputy commissioner in review petition, because they had filed a review petition also after the appellate court had upheld the decree. Well, what we'll see on 3/12/2015,
That was the order passed by the trial court directing the state, that means judgment debtor, to deposit 50% of the decretal amount by way of a bank guarantee. And accordingly, this bank guarantee also was furnished by the state, and I had encashed the amount also. Now they have come before this court to set aside that we should refund the money also. That's one of the prayers made. Now on 4/3/2016, my lord, the trial court had directed the rural bank to transfer the amount of 5 crores to the account of the respondent, which was accordingly done. And on 7/3/2016, my lord, the bailiff was directed by the executive court to provide the bank statement of the judgment debtors for the report. I'll pause here for a moment, my lord. After the review petition was dismissed by the appellate court, they came before this court by way of RSA. What page is that RSA?
RSA number 5.
119,
119?
119.
120 is the order.
Well, we'll find this in page 119 of the revision petition. 120.
This is the order?
Yes, this was the order passed by this court. Heard Mr. P.K. Dutta, learned counsel appearing on behalf of the appellant state, who submits that the respondent plaintiff admitted the fact that bill number 1157 to 1230 may be double bill due to mistake. The learned trial court below, by judgment dated 19/8/2011, mentioned and reflected about the double billing, but has not considered the impact of the piece of evidence as referred above. Hence, the instant second appeal before this court. Also heard so-and-so, learned senior assisted by so-and-so, learned counsel for the respondents, who honestly submits that this is a fit case which needs to be remanded back to the learned trial court for further examination in respect of those bills. Only these bills. I agree with the submission advanced by so-and-so, and so learned counsel for the appellant state also consented to the same. Considering the facts and circumstances of the case and the submission advanced by the learned counsels at the bar, the matter is hereby remanded back to the learned trial court concerned to look into the matter afresh in respect of the bills mentioned above. In the meantime, if the appellants desire, they can file an application before the learned trial court to explain the situation as to why they could not file the written statement in time, and court to consider the same. It is also further mentioned that I am not going to set aside the entire judgment dated 19/8/2011, as the dispute between the parties regarding the double billing mentioned above. Only let the learned trial court confine to decide the matter regarding double billing until unless it is required to examine other further issues. The learned trial court below is directed to dispose of the matter expeditiously, probably within a period of 3 months from the date of receipt of a certified copy of this order. But the double billing here, the double billing in respect of these bills works out to around 26 lakhs out of the decretal amount, 8 crores. This court has held that I am not going to set aside the entire decree. It's only in respect of those bills, the double billing bills, which works out to around 26 lakhs. Now, in fact, the state was given the liberty also to approach the trial court. And try to satisfy the trial court why they did not file the written statement, why the money suit had proceeded ex parte, which was never done. Even after this court had observed, rather given them a chance to go before the trial court, they did not do so. Now, my lord, all these orders which they have challenged by way of this 227, all these are appealable orders. Firstly, we'll come to section 47 of the CPC. Admittedly, my lord, half of their amount has already been deposited by the bank guarantee. They furnished bank guarantee, and now they've come before this court to challenge that, to say that we return back the amount. Is it permissible under 227? Lordship, 47.
Yes.
Questions to be determined by the court executing the decree. All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. If at all they are aggrieved, they have to file an application before the executing court and not by a separate proceeding. Where a question arises as to whether any person is or is not the representative of a party, such question shall, for the purpose of this section, be determined by the court. Explanation 1. For the purpose of this section, a plaintiff whose suit has been dismissed and a defendant against, these are not important matters. And B. All questions relating to delivery or possession of property to such purchaser or his representative shall be deemed to be questions relating to the execution, discharge or satisfaction of the decree within the meaning of this section. If they are all aggrieved, the only way open to them is to approach the executing court, which they have not done. Now they have come before this court challenging also the subsequent, because as I said, my lord, this court had given the state a chance to approach the trial court for giving their explanation if they feel like, which they did not do. And the trial court accordingly proceeded with the case ex parte also in the second for those disputed bills. There also a decree was passed. And by way of 227, now they're seeking to challenge that also, which is an appealable order. Look, 47 out of 47. The question here, my lord, whether this court under 227 will can pass any orders in favor of the petitioner as per the prayers which they have made in their petition.
We are all aware,
yes,
as to
these are
scope and ambit of
227. Yes. So my contention, my lord, is that this revision petition, on the face of it, is not maintainable under 227. 227 is a supervisory, but when there is an alternative remedy, then they cannot approach this court by 227 and making aspersions against the court and the councils. Lord, it is their case that a special counsel was appointed by them to appear in this particular suit. That I am not aware. I am the plaintiff. I am the decree holder before the trial court. A person had come and represented himself, who is also a GA, a GP. She had appeared before the trial court. And now what is the stand of the state is that that particular advocate has not been authorized. Now how will the court, how should the court know? Or even me? They should have been more, in fact, I'll just, they should have been more diligent, man. After all, even in the first instance, the suit proceeded ex parte. That's how I obtained the decree. After this, court gave them a chance to again go before the trial court for that disputed amount. Then also they remain absent. And now by this petition, there's seeking to cast aspersions on the court, which is not permissible. The court has done nothing wrong. My lord, will come to page 138.
Yes.
138. This is a letter by the Director of Sports to the then government pleader, lower court.
Yes.
With reference to the subject cited above, I am to inform you that regarding the order dated so-and-so, related with the above money execution case number so-and-so, noted under reference, this department would like to know on what ground your assistant, Srimati so-and-so, is representing the case on behalf of this department without consultation with our civil lawyer engaged by the department, Shri so-and-so, as recommended by Law Department in consultation with the Advocate General, Government of Meghalaya, High Court of Meghalaya, and our government pleader, Shri so-and-so, who is dealing with the case on our behalf, and neither prior intimation to the undersigned for furnishing relevant information of the case history and other related materials related with the case. In the light of the above, I am therefore to request you to kindly clarify the above confusion, etc., at the earliest for forward transmission to the higher authority. Now, what happened to this letter, we are not privy whether any action was taken. But the fact remains that the counsel who had appeared in this case was a government advocate. The court could not have been faulted for entertaining her presence. In fact, when they came to know about this fact, did they do anything? Did they file any application before the trial court? No.
So there is an element of of a collusion being suspected.
Maybe. That's what they say. But even if that is the case, my lord, they should have filed an application before the trial court to set aside that ex parte order, not by coming before this court under 227. Suppose, even the counsel who had appeared was not authorized, which the court and I am not aware, they ought to have filed an application before the trial court. Not come under 227 and start casting aspersions and saying that there is a collusion, as the Lordship had correctly shown. By way of this 227 petition, what they are seeking to do is to return back the money which they have already paid also, which they have accepted. That is a decree of the court upheld by this court, in fact. The only amount which was left was 26 lakhs in respect of the disputed bills, and that also, the decree has been passed, which has never been challenged by them, and being sought to be challenged by way of 227. My lord is very well aware regarding the contours of 227, so I need not cite any decisions on this point. My prayer is that it should be dismissed only on the ground of maintainability. Subject to what my friend says, I will reply. That's only in respect of maintainability, not on the merits of the matter. Merits maybe in the second case. In the second case, my lord, as I had pointed out on the earlier occasion, now the second case has been filed by the Secretary of the State Sports Council, who also happens to be the Director of Sports. He has filed, in the second case, the Secretary of State Sports Council has filed a case against me and the Director of Sports, which he is also holding the post. So he is filing a case by himself against himself also. That is the second case. I'll come to those.
That can be
in the second.
The senior counsel has rightly pointed out the scope of 227. 227, the scope is limited, but it's not that narrow. Now, my lord, powers under 227, the High Court in exercise of its powers under 227 can these powers can be exercised where orders are passed in grave dereliction of duty or in flagrant abuse of the fundamental principles of law. My endeavor here, my lord, will be to demonstrate that this petition comes well within the ambit of Article 227, because there has been the orders which have been passed in dereliction of duty and in flagrant abuse of the established principles of law. Now, my lord,
first you have to explain your conduct.
My lord, all the orders referred to here by the learned senior counsels, my lord, there is no dispute that all these orders are all these orders were ex parte orders. Now, my lord, how the entire matter started, my lord, we have to go into the genesis of the matter. Now, my lord, the genesis of this entire case is a pending bill which, as on June 2020, payable to a certain firm, was 2,66,28,031. Now, this was the pending bill. Now, against this pending bill, for recovery of this pending bill, a writ petition was filed before the then Guwahati High Court, being WPC number 168H of 2003. Now, in WPC number 168SH of 2003, the state government admitted its liability to the extent of 1,15,44,930 only. And the remaining sum, that is 50 lakhs and 244, were disputed. Now, accordingly, an order was passed. This is at Annexure 1, page 23 to 26 of the revision petition. This is an order dated 31/2004. This is page 25. Annexure 1, it starts from page 23. The relevant portion is page 25.
Yes.
The order reads it under hurt so and so, so and so, so and so. The grievance made in this writ petition is in respect of non-payment of petitioner's pending bills amounting to 2,66,28,031. The petitioner asserts that he is entitled to the said amount on account of supply of the sports good. The learned counsel for the respondent disputed the claim of the petitioner and state that as against the claim of 2,66,28,031, the petitioner is entitled to only 1,15,44,930. This court, while entertaining the writ petition by its order dated so and so, provided that the pendency of the writ petition shall not be a bar for the state respondents to examine the claim of the petitioner and make payments to the petitioner for the admitted amount of bills submitted by her. Reiterating the said order, I dispose of this writ petition with a direction to the respondents to examine the claim made by the petitioner and pay her the admissible amount. Necessary payment shall be made within a period of 4 months from the date of receipt of a certified copy of this order, which the petitioner shall furnish to the respondents. Learned counsel submit that the petitioner may be given liberty to take such appropriate legal actions towards realization of the balance amount beyond the admitted amount. Liberty is granted. Well, not by this order. By this order, that the state has admitted its liability to the extent of 1,15,44,930. This is the admitted liability. Now, out of this, and the remaining out of 2,66 lakh, 28 and 31, this was disputed. Now, out of this admitted amount, a sum of rupees 50 lakhs 244 was paid to the petitioner, was paid to the respondent, Now again, in 2005, the respondent filed another writ petition for the same outstanding amount of government bills. Now this time the petition was filed for release of pending bills of 2 crore 19 lakhs 28,031. Now this writ petition, which was numbered at WPC number 407 SH of 2005, was disposed of by the then Guwahati High Court in its order dated 18/11/2009. Now in this order, which is at page, which is Annexure 2, page number 27 to to 35 of the revision petition. Now I will come to the relevant paragraph.
Yes.
Which is at page 35, paragraph 9. While disposing of this writ petition,
Page 35.
Page 35, the
Paragraph
Honorable High Court at
9.
para 9 has held as under. I will just read the relevant part, my lord. For the above mentioned reasons, this writ petition is partly allowed. The state respondents are directed to pay a sum of rupees 65,44,606 only to the petitioner within a period of 2 months from the date of receipt of this judgment. As for the remaining 1,50,73,101 as claimed by the petitioner, he may seek address from a competent court of civil jurisdiction. If so advised, the parties are however directed to bear the respective cost. Now, by this order, the High Court made it very clear that out of the admitted amount of 1 crore 15 lakhs something, 50,000 of 50 lakhs of which is already paid, the remaining 65 lakhs and some thousand rupees is to be paid within a period of 2 months from the date of receipt of the judgment, and with regard the remaining 1 crore 50 lakhs 73,101 as claimed by the petitioner is at liberty to file an appropriate suit before the appropriate court and seek his relief. Now what happened? Thereafter, the money suit ought to have been filed for what amount, my lord? The money suit ought to have been filed for a sum of rupees 1 crore 50 lakhs 73,101. However, a suit was filed for a sum of rupees 8 crore 88 lakhs 44,824 along with interest at the rate of 12% per annum. Now, on what basis was this filed? It's not known to us. Now, this suit was decreed against us ex parte. Suit was decreed against us ex parte. I will just take my lord to the. Let's go to the money decree. My lord, the decree is at early preparedness. This is the decree, Annexure 5, page 66. Page 66 to page 66 to 69. This is the decree. A suit for recovery of money valued at so and so, so and so, so and so, so and so. The actual dues accrued and accrued interest till 31/12/2009 from the date of institution of the suit till the date of the decree, thereafter till the realization of the decretal amount from the defendants. Now, my lord, the whole problem here is the manner in which the interest was awarded.
Yes.
My lord, will kindly come to the interest component.
Yes,
As in a money decree, my lord, the interest component ought to have been calculated using simple interest arithmetic. However, here compound interest was awarded. So therefore, my lord, the court has acted.
This figure of 1 crore 50 lakhs appears here.
It appears it appears there, no doubt, my lord.
So it means that when the suit
My lord, kindly come to the suit, my lord. The suit was filed for recovery of 8 crores.
8 crores.
8 crores,
if you
88
say
lakhs.
so. But the decree was for 1 crore 50.
My lord, this is the money suit. Money suit is at NHA 3, page 36. Suit valued at rupees 8 crores 88 lakhs.
Yes. So whatever the claim in the suit,
My lord.
finally what would be effective would be the degree itself.
My lord. Now, my lord, in the degree itself, my lord, kindly see how the interest has been computed, my lord. So therefore, my lord, this is clearly a case of flagrant abuse of fundamental principle of law. The decree could not have been effected in this manner. The interest component could not have been effected in this manner. That is my case, my lord.
Oh, yes, of course.
So therefore, my lord, when such is the situation, my lord, the powers of the High Court under Article 227 travel beyond its narrow scope of being a supervisory jurisdiction to correct such errors also, my lord, where the court has acted in flagrant abuse of the settled principles of law.
Yes.
In a nutshell, this is my case, my lord. Now, my lord, subject to what my learned senior has to say, my lord, if I am given some more time, my lord, I will have to elaborate on these on this principle.
See, just a moment. I've just gone to this second page, where the figure of 1 crore 50 lakhs appears. So, the next page says, and that the sum of rupees 7 crores 10 lakhs. Where does this 7 crores 10 lakhs come from?
This is what needs to be examined, my lord. This is what needs to be examined.
Your Lordship, this decree has been upheld by the trial court and also by this court in RSA. Now, can this court under 227 again open up the issue? That is my...
No, that cannot be.
My lord, kindly look at how the RSA was decided, my lord. Can a second appeal be decided
even the review was filed.
Formulating a substantial question of law?
RSA was filed.
Recently, the apex court has held that you cannot decide a second appeal without formulating a substantial question of law.
Whatever the case may be, rightly or wrongly, the order has been passed in the RSA.
Yes.
Have you appealed against the order?
They have never appealed. That is the question.
My lord, it has not been appealed, my lord.
Then what do we do?
It has not been appealed, my lord. But my contention is,
Mr. Gautam,
my lord.
Simple logic is this: can a court of coordinate strength overrule a decision made by the same court?
My lord, it can of course have a different view. My lord is sitting here as
That would be
All
under
along
227,
they're
my lord.
sleeping, my lord. The government was all along sleeping.
But at
So
what
much
cost,
of-
my lord?
So much of money was
whatever the
involved.
case may be. See, even
At what cost?
let us speak out of the records.
My lord.
Yes.
There could have been a case of flagrant violation of whatever principles. There could have been a case of collusion, could have been a case of corruption, there could have been a case of miscalculation, whatever the case may be. But whatever the case may be, that has come under judicial scrutiny before appropriate authorities, particularly before this court. And the court has been rightly pointed out, this court has rightly said that the judgment and degree will not be touched, except for those, that overbilling amount.
My lord.
But then,
My lord, I bow down to what my lord has said, that this matter has come up before this court, but not in exercise of this jurisdiction, my lord. The jurisdiction under Article 227, my lord, is wide in cases of this nature, my lord, and that will be my endeavor to satisfy my lord. My lord, if we can have this matter.
What my learned friend is saying, that this court may pass an order in an RSA, which can be subjected to a jurisdiction under 227. In fact, my lord, in the RSA, the state government had consented and saying, yes, it is only this amount.
My lord, I sincerely, my lord, my submission is my learned senior friend here will not dispute to the settled principle of law that what is void ab initio cannot be subsequently rectified by any act.
true, but then you see, you have
So,
to
my lord,
you have to follow the
kindly look
proper
into this, my
you have
lord.
to follow the proper procedure. You have to approach the higher court for that matter, and an appropriate order will be passed.
And again, my lord will look into the pleadings in the appeal as well as in this court. These issues are never raised. They ought to have been raised.
Also, my lord, there is another element. My lord, of late the courts have held that any decree or any order of a court which is obtained not by fair play, or which is a product of deceit, fraud, if I may say, if I am permitted to say, is non-estate law, and it can be challenged at any level, even in a collateral proceeding.
Let us do one thing, Mr. Gautam.
So, my lord,
On the query of this court, you try to find out some authorities,
my lord,
specific to the issues.
specific to the issues, my lord.
And if there's a leeway that can be given to you, fine. Otherwise, prima facie, I find that this court, the hands of this court is tied. That is judicial discipline and property.
What is at stake here, my lord? It's public money at large.
True, public money is public money, but who is responsible for it at the end of the day? Your own conduct says
The
so.
law provides for adequate mechanism to take care of those who are responsible.
Exactly. But perhaps not at this forum. What we can do,
my lord,
Mr. Gautam, what I can do, dismiss your petition and you approach the higher court. Perhaps you may succeed.
Give me an opportunity, my lord. I will at least make a last ditch effort to salvage my my case.
This is public money, my lord, but what does state look at since 2009? They were given so many chances.
My lord, all the orders were ex parte.
No, ex parte why? Because the state never took any.
My lord, the state is a non-living entity which is manned, managed, and administered by living entities. And living entities.
So now you expect the courts to come to your rescue.
For your own shortcomings, this court has to bail you out. Very doubtful.
Well, give me a last opportunity, my lord. I'll just come up with something. If, in fact, to be very honest, I was not fully prepared also to address this court on this issue today.
No, the only issue is that whether it's maintainable or not under 227. That is all.
Maintainability, well, we'll look into it.
But again, my lord, in a case of this nature, maintainability is a law and facts. Both, my lord. It cannot be looked at in isolation.
But it is not a case where they have approached appellate court, review before the appellate court, before this court.
My lord, I must say only petitions were filed, But
Fine. So when do we have it?
Next week, my lord. Well, this is a 2016 matter.
It should be disposed of at the earliest.
So far as the other CRP is concerned, I would also like to address the issue.
Yes, so we'll hear Mr. Gautam first. Then you'll follow suit.
my lord, on the 28th, if it is convenient to my learned senior, I have some, or on 27th.
Well, again, we'll have to start. The issue is very short, it's very small.
Oh, but these.
Well, we leave it after 2 weeks, then you forget the.
There are so many twists and turns, so many unanswered.
My lord, I am already sailing on a sinking boat, so some amount of compassion may be shown to me.
26.
And aptly demonstrated by my learned senior here.
26.
No, 26. I have matter in body.
Okay, fine. 28.
20. Oblige me.
Matter has been heard partly as submitted by the parties. Place this matter on 28 for further hearing.
Item number 12.
Yes. Who's here?
Please.
Yes, Mr. Kumar, tell me.
Now, Your Lordship has heard the petitioner on last date of hearing, and therefore, my lord, what is required for me to establish my case is to take through their whole case. What is their case, my lord? And for that, I would request Your Lordship to kindly see the writ petition filed by petitioner.
Just a minute. The petitioner is not here, Mr. Kumar. Excuse me. I think there are two connected matters here.
Yes, there are two connected matters, my lord. There are two connected matters.
Represented by
item 12.
Represented by different counsel.
One is by SD.
Yes, different counsel. In one, Mr.
SD.
Sangreso, learned senior counsel was appearing, and the other matter, my lord, Mr. Day was appearing.
Yes, you are ready?
Yes, I am ready, my lord.
No, I am asking them because they have to, you see, after you finish, they'll have to
Yes,
respond.
Yes, your lord. Yes, your lord.
Hmm? What do we do?
Lord, I'm your lordship's hand now. I am
since they are,
but they have to reply, my lord. They have to answer after my argument.
Since the counsel are on legs in the other courts.
Yes, my lord.
And I think his colleague can note down the points submitted by our AG. Then when the senior comes, they can reply.
Let it be in the presence of the senior counsel, because ultimately learned senior counsel has to reply to my arguments, and because I am raising preliminary issue as to the maintainability of writ petition, because it is barred by delay and latches also, my lord.
Okay.
So because that's a preliminary issue as to the maintainability, because what they are claiming, and I am relying on number of authorities also. So therefore now because it can be taken up tomorrow also, my lord. I am ready. It can be taken up tomorrow also. I have no issue, my lord. I can argue them.
The senior crediting counsel is here.
Oh, he is here. You are ready?
Yes, my lord. Kindly take.
Ready.
Yes,
So
my lord.
we'll take up your matter first then.
Yeah, 279, writ number 279 of 2021.
Please start.
Your Lordship, kindly see the synopsis first, my Lord, so that Your Lordship will get the glimpse of the matter or the brief facts about the matter, my Lord. What is the claim which the prisoner is agitating before Your Lordship? Synopsis, my Lord.
Yes.
That the petitioner begs to state that she has been considered for supply of 3,248.5715 quintal of cattle feed and 1,428.5717 quintal of pork feed and 1,428.57 quintal of poultry feeds at the rate of 35 per kg to affected animal as per norms approved and approved rate of expenditure for supply of flood affected areas accordingly wide later dated 8 December and 21st January. Your Lordship may kindly kindly take note of these two dates. What is being said? The order of supply of this much quantity of cattle feed at the rate of 35 for everything, for cattle, pork, and the period Your Lordship may kindly mark by order dated 8 December 2014 and 21st January 2015. The respondent animal husbandry veterinary officers, North Garo Hills, my Lord.
Yes.
Now this order was placed, and for that Your Lordship kindly come to the next page of the same synopsis, my Lord. Same synopsis, my Lord. Next page.
Yes.
The respondent authority till date, that is almost for a period of 7 years, failed to receive. So admittedly, this petition has been filed after 7 years, my Lord.
Yes.
And amount claimed is 2 crore to 20 lakh rupees for the above said supply, which was effected on 8 December 2014.
Yes.
Now kindly see that light, my Lord, the factual position in the writ petition, my Lord. What is being said, my Lord, at paragraph 3 at page 4?
Yes.
That on 22/9, Your Lordship, paragraph page 4, paragraph 3, in the brief, writ petitioner begs to state that while meeting dated 15 December 2014, held by the respondent authority, a decision was taken for formation of committee in connection with the approved rate for supply on urgent and emergency need. Your Lordship may kindly mark urgent and emergency need for supply of animal and poultry feed due to recent flash flood landslide that occurred on 22/9/2014. So 22/9 is the date of flash flood, my Lord, 14, and the meeting was held on 15th December, as per the petitioner himself, my Lord. Flash flood, and for that a claim of 2 crore 20 lakh rupees is made, my Lord, for last 7 years, and the rate is approved at 30.
Yes.
Now Your Lordship will see on next paragraph also, because very interesting facts are narrated, my Lord. Meeting was held on 15th December. On paragraph 4, my Lord, what the petitioner begs to state, by the order dated 5th December. So meeting is on 15th December, order is placed on 5th December. 10 days before, meeting takes place later, and order is placed prior. 15 December 2014, my Lord. I'll take Your Lordship through the annexures also, my Lord.
Yes.
That now the petitioner refers to various orders. Now kindly see next date, paragraph 6, my Lord.
Yes.
Additional on 21st January 2015, additional intake. Additional. Your Lordship has taken note of the date of flash flood, which was on 22/9/2014. In January also, flash flood is over, everything is over, and the additional order is placed, my Lord. And then, my Lord, the utilization certificate is there, my Lord. Kindly see, these are the disputed. In the light of these, my Lord, kindly see the annexures, my lord. What is their case, my lord? Prayer, my lord, at page 10.
Page 10.
Page 10, prayer is there, my lord.
Yes.
That direction is from this honorable court, my lord, in the prayer to release the bill of the prisoner as that the inordinate delay on the part of state respondent to release the bill of the respondent petitioner as unconstitutional, illegal, and further please to direct the state respondent to release the bill of petitioner within a period of 3 months. So direction from this honorable court, writ court, is for release of payment after 7 years, and it is a kind of, in my humble submission, in the light of disputed question of fact, it is a kind of recovery suit which they have filed without paying any court fee and knowing fully well that even recovery suit is barred by time, my lord. But be as it may, my lord, kindly see the minutes of the meeting on which the reliance has been placed, my lord, at page 14. This is, my lord, minutes of the meeting, my lord.
Yes.
Held on December. Now, you lordship will see the members present, etc. The meeting was chaired, next paragraph, DD Sanma so and so, and who welcome also and so. Meeting, now point number 1, my lord. Meeting decided first to constitute the committee in connection with approved rate for supply of feed on urgent basis for an urgent and emergency need for supply of animal and poultry feed due to flash flood, landslide occurred on 22/9/2014. Your lordship, kindly bear this fact in mind that flash flood as per petitioner and as per the annexure has taken place on 22/9/2014. Flash flood, my lord, cannot last more than 2 months, 3 months. And the order, and on 5th December, the order is being placed. Now the meeting, now kindly see paragraph 3, my lord. After threadbare discussion, the committee of the meeting has been approved at rate of 35 only per kg for transportation and for supply of feed of animal and poultry feed for the affected people in North Garo village. Now the meeting approved 3 number of farm suppliers and for supply. So now they approved 3 number of suppliers, my lord. This is the order which they are, my friend is placing on page 15. Then the order is placed on the petitioner at page 15, my lord. Page 15 of the writ petition.
Yes. On the same day of the meeting.
Yes, your lordship has seen. And then on 8th December, my lord, if your lordship will see that page 16, my lord,
yes,
the cattle feed is 3,428 quintal.
Yes.
And 1,428 quintal, my lord. This is a huge quantity of the cattle feed placed the order. Your lordship, if I calculate that one truck will have the capacity to take at least 10 to 12 so that way at least 300 minimum trucks will be required, my lord. So this is the, and then again, my lord, at page 4, the district animal and husbandry officer has purportedly again placed the order. Place the order. Then, my lord, if your lordship will see the utilization certificate, I don't know.
Yes.
Utilization certificate at page 18.
Yes.
The page 18 certified that now this certificate, they now rely on this certificate, my lord. This is also, your lordship, kindly mark, this is undated. There is no date on this. To mine, I couldn't find any date on this page, my lord, at page 18. Utilization certificate. And this utilization certificate is again being given by Mr. D. Roy, who placed the order in 2015. He doesn't see the date on which he has received it, my lord.
Yes.
And then, my lord, your Lordship will see the next letter of Deputy Commissioner at page 19, which has now page 19 in 2018, my Lord. What Deputy Commissioner is, with reference to the letter cited above, he is forwarding it to the Revenue and Disaster Management Department, my Lord, on 4th October. With reference to the letter on the subject cited above, I am to forward here with a copy of letter under reference received from the District Animal Husbandry Officer so and so with the resubmission of bill for supply of feed of the livestock of family affected by flash flood in this North Garo Hills by Priyanshi Maharaj. In this regard, the concerned District and Animal Husbandry Officer Rasul Bara has resubmitted the bill challan with the relief camp set up during the flash flood. Your Lordship might kindly mark relief camp set up during the flash flood 2018.
Yes.
So now relief flood, so camps have been set up as per the Deputy Commissioner, my Lord.
Yes.
Now the clarification is, your Lordship will see at now 21.
Yes.
The clarifications, then the matter came before your Lordship. Your Lordship directed to dispose of the matter. We disposed of the matter.
No, what is this clarification about?
Regarding whether relief camp.
This is clarification by the petitioner.
By the government, my Lord. Sorry. I'm sorry, I pointed out the wrong annexure, my Lord. That is at page 21. Page 21, annexure.
Page 21, annexure
8. Annexure 8, my Lord.
Okay. So this is the letter by
the again Priyanshi Maharaj to the district, and he is saying that he has invested huge expenditure. Kindly consider his application, my Lord. Then he came before your Lordship at page 22, annexure 9, in the by way of writ petition.
Yes.
Then direction was issued to the state government.
Yes.
To clarify the position, my Lord, and then we have passed the order denying it. My Lordship, now kindly see my counter affidavit. Your Lordship has got the picture of the whole case, that there was a committee which purportedly met in December for supply. For that committee approved some rate of 35 rupees. For flash flood which has taken place on the date is 22nd September 2014, my Lord. And then thereafter, after 7 years, he is coming before your Lordship saying direction to the state government to make the payment, my Lord. Now my counter, if your Lordship will see, because I have raised number of preliminary objections, and there are two counters, one filed by the respondent number 5, my Lord, which is, your Lordship may kindly see the counter affidavit filed by respondent number 5.
Yes, this is.
And page 3, my Lord, I have taken the preliminary objections.
Yes.
Page 3, my Lord. Yes. In page 3, my Lord.
Yes.
I have taken the ground, my Lord, and I'll refer all the judgments, my Lord. Writ petition is not maintainable in commercial matters. And then, my Lord, I have cited those judgments, my Lord. I will show those judgments, I will rely on those judgments. I have also culled out the relevant paragraphs of the judgment, my Lord.
Yes.
And if I can place that some of the judgments in paragraph 10, my Lord, at page 4. That paragraph 10, my Lord.
Yes.
There is a line of decision, paragraph 10 at page 4.
Yes.
Decision, where it has been held that contract entered into between the state and person aggrieved is purely contractual right are governed only by terms of contract. no writ or order can be issued under 226 of the Constitution, my lord, and paragraph 11 at page 5.
Yes.
In Joshi Technology International versus Union of India, the following was held. 55. Law in this aspect has developed through a catena of judgment of this court, and from the reading of these judgments, it would follow that in pure contractual matters, extraordinary remedy of writ under Article 226 or 32 of the Constitution cannot be invoked. However, in limited cases, such remedies are available only when non-government contractor is able to demonstrate that it is public law remedy which such parties seek to invoke in contradiction to the private law remedy. So, what is the onus is on the contractor or the petitioner to show that it is a public law remedy, and then only he can come before your lordship for direction, my lord. In Ajay Pal Singh versus so and so, my lord, I will place the judgments, my lord. I have prepared a compilation separately, and I will take your lordship to those judgments. I am just briefly indicating my argument, my lord.
Yes.
It is a contractual matter, and writ is not maintainable. But before I take your lordship to those aspects, first, my lord, paragraph 18 on merit, which I have attempted to answer the.
Yes.
And your lordship will see.
Excuse me. Paragraph 18.
Paragraph 18, which and the heading is submissions on merit, my lord, at page 10.
Yes, please go ahead.
Yes, and you also will see my paragraph submission in paragraph 19. I will start, my lord, page 11.
Yes.
Accordingly, while data dated 24th number so and so, district animal now requested for supply of animal and poultry on short notice. After inquiry, the district disaster management committee identified the petitioner as to make a visit. On 5th December, paragraph 21, Deputy Commissioner convened the meeting, which I have already placed before your lordship, my lord. And the bottom of the paragraph 10, my lord, paragraph 11, last 3 lines.
Yes.
The applicable legal provision under which above requisition was made is para 6 small Roman 2 of State Disaster Response Fund and National Disaster Response Fund, which pertains to animal husbandry assistance to small and marginal farmers. So it is a disaster, and it has to be under paragraph 6 small Roman 2, my lord.
Yes.
I have placed it as annexure 1, my lord. I will take your lordship to that part. Now paragraph 22, my lord. It is to be noted that the State Disaster Response Fund is constituted under section 48 of small 1A of DM Act, Disaster Management Act 2005, and is a primary fund available with the state for response to notified disaster. Central government contributes 90% of a special category state, northeastern state, etc. my lord. In the above matter, the short note is supplied or issued to the petitioner after due approval. It appears that records on 4/10/2018, Annexure 6 of the writ petition, Deputy Commissioner forwarded the bills along with the certification received by AH. Now 25 million. At this stage, the state government through revenue and disaster management raised certain objections as to the clearance sought for the bills. This was conveyed to the Deputy Commissioner while later dated 2/9/2000, wherein inter alia following information in connection with petitioner was sought. Copies of the supply orders. B. Whether the distribution of fodder was done in cattle camps and number of days in which cattle were housed in the camps. These are very important facts. Because how many days for you have supplied, how many days, it appears that queries were raised to ascertain the compliance with requirement of para 6 small 2 of State Disaster Response Fund and National Disaster Response Fund pertains to animal husbandry assistance to small and marginal farmers. While later dated 6/10/2000, Office of the District Animal Husbandry Officer informed Deputy Commissioner that relief had not been set up due to various reasons. 6/10/2015, my lord, that relief camps have not been set up, including reluctance of the vigilance to bring the cattle to these camps on account of fear of misidentification. So there is no camp, my lord. poultry feed is supplied to cattle situated where, my lord? In what area? Now, when these objections were raised, my lord, I will just
see this was done on the basis of your internal inquiry.
Yes, this, my lord, it was based on my internal inquiry. The issue is, my lord, if there is an order placed by the state or district disaster management fund saying that we have placed the order in all districts, we have got district disaster fund authority, my lord, we have placed the order. Then the authority will verify whether actually you have placed the order or not. And if you have placed the order, you have placed the order in accordance with the statutory provisions or not. What, my lord, in this case, very bizarre is that now my friend is claiming 2 crore 20 lakh rupees. In connected matter, for same flat cattle feed for same area, another 2 to 3 crore rupees is, I don't know exact amount, I'll have to check. Another, and there is a third supplier who is also claiming. So for flash flood, which has taken place on 22/9/2014, my lord, 7 to 8 crore rupees are being demanded. And in one supplier, my lord, under which there some payment is made. Now, on that basis, these two petitioners are also saying if the payment has been made to them, illegality has been something you give me that payment also, whether I comply with the requirement of law or not. That is the disputed question of fact which is before that, my lord. Because therefore, in the light of these circumstances, whether with Article 226, your lordship is fully aware that it is a equity jurisdiction, my lord. The petitioner has to establish in each and every fact, including why did he not approach your lordship well within time. Because your lordship, right now, after 7 years, or now 9 years, collecting and collating data and ascertaining his claim that he supplied the cattle feed in December of 2014. Order is December 2014. I don't know what was the period, how many trucks from where he bought those cattle feed, where is the GST challan or not GST, those were not GST, sale tax challan, because he must have purchased it from outside Meghalaya. Or if, for example, if he has purchased in Meghalaya, there will be documentation backing his claim that I have purchased and I have supplied. And he supplied, and when it was distributed, where was it distributed?
All these documents would have been forwarded to the authorities concerned then.
Your lordship, that is what I say. If my petitioner's first duty before your lordship is that he has supplied those documents. And I have gone through the entire petition with your lordship, annexure by annexure. And the lordship will not find a single annexure saying that I have spent this much money in procuring, because in all probabilities, my lord, the flash flood is over, cattle are not in the camps. Now, what has happened, one interesting fact which I must place before your lordship is that what is being, when the objection was raised that there was no, you did not have the cattle in enclosures or in the objection was raised. Then they said, no, this was inadvertent error. We created the enclosure.
So there was no cattle count.
There was no. They said no earlier. If your lordship will say, if I just read that paragraph once again, my lord. Paragraph 25. Cattle camps, my lord. If paragraph 25 at page 13.
No, I'm talking about cattle count.
No, cow is there, my lord, the pig and also poultry farm. Everybody every cattle and 35 rupees per quintal, my lord. That kind of for copies of supply order, whether distribution of order was done in cattle camps and number of days in which cattle were housed in the camps, my lord.
Yes.
Now, in response to this, my lord, in paragraph 26, veterinary officer informs that relief camps had not been set up. Paragraph 25 at page 13, my lord.
Yes. Yes.
Whether whether the distribution of fodder was done in cattle camps and number of days, this is the query, in which the cattle were housed in the camps.
Yes.
And the reply by annual husbandry officer, my lord, is that inform the Deputy Commissioner that relief camps have not been set up due to various reasons, including reluctance of villagers. So the answer is that there is no relief camp.
That is page.
What has happened, my lord, is another disputed question of fact. Yes, Mr. Brown.
That is page 27, annexure, page 27, annexure R2, filed by the respondent number 5. Annexure 20, page 27, Your Lordship.
Yes, Lord. So kindly see the annexure for a moment, my lord.
27, page 27, sir.
Page 27, my lord. A friend has rightly pointed out the annexure, my lord. Now,
this is the reply.
This is the reply by, because when the queries were raised that whether cattle farms were set up or not, how many days cattle were housed in the camps, were placed in the camps, then the reply comes, my lord. With reference to the subject cited above, I have to honor to inform you that relief camps for flood affected livestock could not be set up during the flood due to shortage of manpower. Moreover, the affected villagers were so reluctant to bring their livestock and poultry to relief camp due to fear of misidentification and misplacement. Most of the affected are interior areas, and roads and bridges connecting to their village have been washed away during the flood. It is all more difficult to bring livestock and poultry to the camps. So the relief camps meant for them are left unused, and feed or light were distributed through village gown buras, nokmaj, etc. Now kindly see this, the contents of this letter.
Yes.
And they say that cattle, there was no setting of the cattle relief camps. It also says that the bridges, etc. were washed out and they were in interiors. And still the cattle, 5,000 metric ton of cattle were one by one distributor, one supplier, were distributed in far off areas. In my humble submission, my lord, this is a public money, and with humility, my lord, on my command, what I say is that if there is some collusion, whether they can come and invoke equity jurisdiction after your lordship after 7 years, saying that the payment has to be made to the supplier. And now, most bizarre thing is that, my lord, when this kind of why was this objection raised, my lord? Now, if your lordship will see the requirement at page 25, the requirement of law, when you have to page 22, it is the revised rate of list, page 22, annexure R1.
Yes.
Revised of items and norms of assistance. Your lordship at the top of page 22, annexure R1.
Yes.
Revised list of items and norms of assistance from State Disaster Response Fund and National Disaster Response Fund, my lord. And this is the letter of MHA, my lord, this. And this is a disaster under which they are claiming, my lord. Now, page 25 is the norms for fodder and feed concentrate, my lord.
Yes.
And you also will notice at small Roman 2 at the very first column at the top of page 25. Provision of fodder or feed concentrate, including water supply and medicine in cattle camps. Large animal 50 rupees per day, a small animal 25 rupees per day. Period for providing relief will be as per assessment of a state executive committee. So this will be assessed, and the central team in case of NDRF, default period for assistance will be 30 days. So how many days the total period for supply is 30 days, my lord, as per now, and it may be extended to 60 days, and in the first instance, and case 90 days. So there has to be order that, and your lordship kindly note the date which I have, 22nd September 2014 is the date of flash flood. And after almost 3 months, my lord, against the norms, they are saying that they have supplied the. So if your lordship has to weigh the statutory provisions vis-a-vis the decision of the authority, because the decision of the authority are always subservient and has to give way to the statutory provision. For example, my lord, if I take a case where the Deputy Commissioner has placed the order of 100 crore rupees of cattle feed in violation to these norms, whether state government, because here, my lord, the complicity of the officers and state government, which is representing public money, my lord. State government has to be run because, my lord, what has happened in Bihar, one example, which in cattle feed was being supplied on scooters, etc., and the officers were placing those orders. But ultimately, it was found that look, those orders are per se illegal and against the law treasury norms, and they were being prosecuted for criminal and civil offences, civil matters. So therefore, my submission to your lordship is that when the public interest vis-a-vis private interest, that is why in all these matters your lordships have been consistently taking a view that writ court is not the remedy for all these issues, because you have to prove certain facts. First, you have to prove that you supplied the cattle feed. Second, the cattle farms were set up. Third, that the huge, for example, we lot 5,000 quintal is supplied by one supplier, another 5,000 quintal, and it is in one district. And in one area, the flash flood has taken place, and that has to be for 30 days only, because that way, my lord, so they all norms are violated, and therefore my suspicion or my apprehension is that they did not approach the court or this honorable court also or the civil court in time, as they were not having material to prove the statutory requirement. I put a question to myself: why did not they come to your lordship or to the other forum or civil court in time? Because delay, my lord, I will place those judgment. Delay defeats the equity also, because this is a conduct which is suspicious, not ever board, my lord. So your lordship will see now. I'm sorry, coming back to page 25.
Yes.
A small animal 25 and cattle feed period for providing relief will be as per a statement of State Executive Committee, Central Team. There is no such assessment. Default period for assistance will be 30 days, which may be extended to 60 days in the first instance. There is no order extending it. Based on the assessment need by SEC, recommendation of Central Team in case of NDRF, consistent with the estimates of cattle as per livestock census. My lord, kindly livestock census and subject to the certificate by competent about the requirement of medicine calamity related. So there, and this norm, my lord, if somebody is placing the orders in violation to norm, my lord. Now, what very interesting thing which happened, my lord, that the letter is very clear. Reasons are given why cattle farms were not set up, because they are in far off places. Now, when the objection was raised, now animal husbandry officer is saying, no, it was inadvertent error in the first instance. We have set up the cattle farm. Now this is all shrouded in mystery, my lord. Now, if your lordship will see next page 28.
Yes.
Resubmission. I am directed to refer the government of Meghalaya's writing to the Deputy Commissioner.
Yes.
Revenue and Disaster Management Department is writing to the Deputy Commissioner.
Yes.
I am directed to refer to the letters cited above to say that 6.2 of the, now your lordship kindly, I have already shown 6 small Roman 2 of the State Disaster Response Fund norm state that provision of water feed concentrate including water supply and medicine in cattle camp. Since feed were supplied outside the cattle camp, the proposal of sanction of fund SDR for payment of bill is not eligible under the items and norms of the state in view of the bills and are returned here. You know, this is 2016. and they come to your lordship in 2013. Now your lordship is very interesting. Now clarification now comes, my lord, in 2018 by again, sir, referring to the later number cited above, I had the honor to state that in the bill submitted earlier, there were miscalculation in the amount of bills and quantity of distributed which was duly corrected. The clarification regarding general objection for locality is also included. And then what is your lordship will see at page 30.
This is resubmission. No.
And this is the district and animal and husbandry officer when it was pointed out in 2016 that your norms are contrary to 6 small Roman 2 and there is no cattle farm or cattle camp, and therefore you are not entitled to, you are not covered. Now page 30, my lord, page 30, where now I have shown both the letters, my lord. First letter, why cattle relief camps could not be set up, because they are in interiors, far off places, and therefore villagers were apprehensive, they could not have brought and missed, etc. Now kindly see 30, my lord, page 30, the clarification. In reference to the letter cited above, I had the honor to resubmit here with the bills and other related papers of Priyanchi, along with the list of relief camps set up during flash flood occurred on 21/2. The earlier clarification regarding relief camp was a mistake and it is highly regretted. What do I do with these, my lords, when I point out that you do not follow the norms? These are all absolutely disputed question of facts, my lord. And the regions which what the lordship kindly read that letter at page 27 and read with the letter of page 30. 27 weighty regions are given, my lord. 27. Why relief camps could not be set? Regions are that, and flood due to shortage of manpower. So first reason is that there is no manpower to set up the relief camps. Second, affected villagers were reluctant to bring their livestock and poultry to the relief camp. Who will bring the chicken, etc., to the relief camp? And for that, I have to supply, my lord. Due to fear of misidentification and misplacement, most of the affected villages are interior areas, and the roads and bridges connecting to their village have been washed away during floods, making it all the more difficult to bring the livestock and poultry to the camp. So the relief camps meant for them left unused, and feed of livestock and poultry were distributed to the village, Gaon Buras and Nokmat Sardar's village, etc. Lord, all these facts indicate a deep-rooted collusion, Lord. And they are invoking the writ jurisdiction to get the public money. It is ultimately a public money, right or wrong. It is. Now they created, my lord, beneficiaries list with utilization certificate 400.
Yes.
So what I am trying to submit, my lord, is this, that if your lordship would see that if this case is not a case of disputed question of fact, in my humble submission, no other case will be case where it's all disputed, norms are not followed, and if I take it, if in this case, my lord, if the orders have been placed in violation of the norms, in any disaster, my lord, the local disaster authority will place the order contrary to norm, and in my humble submission, that will not bind the state government. But your lordship need not, in my humble submission, in lordship may not require to go on all these issues, because my first submission is that it is barred by delay in latches and it is raising the disputed question of fact, and your lordship has taken a consistent view. Recently, division bench in which your lordship was also part has taken a view that in writ jurisdiction, disputed question of facts may not be entertained, my lord.
That is
so
well,
this is the
that is well settled.
Yes, Lord. So then, therefore, if I succeed, assuming I succeed, my lord, on this ground, Your Lordship may not go into the faction, because if they have remedy in civil court or any other law, they may follow the remedy, but if your Lordship will return the finding on fact, either in my favor or against, or either in their favor and against me, Lord, that finding will bind the authorities to whom they want to approach in accordance with law. So the point which I was making, my Lord, is this, that the norms have not been followed. Now kindly see the case law on this aspect of the matter. Now, before I go to the case laws, one more fact which I wish to place, my Lord, that during the course of argument they have placed one document on during the pendency of the matter that some payment has been made to one supplier out of 3. My submission is that if the payment has been made to the same supplier, that will not give you right in law. Your right has to flow from your own case. Article 14, your Lordship is fully aware, it talks about the positive equality. There cannot be equality in illegality. So therefore, discrimination plea is also, with greatest respect, my Lord, is misplaced and misconceived, my Lord. Now kindly see, my Lord, my compilation of the cases which I have placed. I have asked my colleague to.
Have you given them a copy of the list?
Yes. Your Lordship will see the judgment, the index first, because index will, my Lord, will have the overview of the case laws which I am relying on citing, my Lord. Now, first is, my Lord, barred by limitation plea, and I have placed the judgment and paragraphs, my Lord. Then contractual nature, thus no writ, my Lord. Then these are the judgments, my Lord. Now, kindly see the first state of MP. And straight away, your Lordship, kindly come to page state of MP. The citation is there, para 24, my Lord, at page 29. I have mentioned in the index, my Lord, paragraph on which I am placing reliance, my Lord.
Yes.
The relevant paragraph is at page 29, my Lord.
Yes.
Now, paragraph 24, my Lord, at page 29. Now it is well settled that power of the High Court to issue an appropriate writ under 226 of the Constitution is discretionary, and the High Court in exercise of discretion does not ordinarily assist the tardy and indolent or acquiescent and the lethargic. If there is inordinate delay on the part of petitioner in filing a writ petition and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in exercise of writ jurisdiction. The evolution of the rule of laches or delay is premised of number of factors. The High Court does not ordinarily permit a belated resort to the extraordinary remedy under the writ jurisdiction because it is likely to cause confusion and public inconvenience and bring in its train new injustices. Right of third parties may intervene, and if the writ petition is exercised on a writ jurisdiction is exercised on a writ petition filed under unreasonable delay, it may have the effect of inflicting not only hardship and inconvenience but also injustices on third parties. When the writ jurisdiction of the High Court is invoked, unexplained delay coupled with the creation of third party right in the meanwhile is an important factor which always weighs with the High Court in deciding whether or not to exercise such jurisdiction. We do not think it necessary to burden this judgment with reference to various decisions of this court, where it has been emphasized time and again that where there is an inordinate and unexplained delay and third-party rights are created in the interference, the High Court would decline to interfere, even if the state action complaint is of unconstitutional or illegal. We may only mention the passing two decisions in the court, one in Ramanna Dayaram Setti versus International Airport Authority of India, and Ashok Kumar Mishra of Second. We may point out in the R.D. Sethi case, even though the state action was held to be unconstitutional, is being violative of Article 14 of the Constitution. This court refused to grant relief to petitioner on the ground that writ petition has been filed by petitioner more than 5 months after the acceptance of tender of the fourth respondent during the period. The fourth respondent had incurred so and so. Of course, rule of likelihood of delay is not a rigid which can cast in straight jacket formula, but such cases the demand of injustice so and so. Now, my lord, 25. Here, obviously, there was considerable delay on the part of petitioner in filing writ petition and intervening period respondent so and so. The point which I was trying to make, my lord, that this is the so alleged supply of the cattle feed pursuant to the order placed in December 2014. We are almost 8 years away from the date when alleged supply has taken place. First, they said it is in cattle. It was not cattle camps were not set up, cattle relief. Then, when the objection and it was said that the period is not mentioned, etc. No, they said that yes, cattle camps have been set up. All these things, my lord, assuming, and if I argue in favor of it, we are correct also for the sake of argument, my lord. This has taken place in 2016-17. Now again, is it possible for the court or for the state government to verify the claim when they are coming before you after 7 years, my lord? Before your lordship they are coming. So therefore the rule of delay and laches is founded in the public policy, and where this public policy is salutary public policy, where the person is saying that I have supplied cattle feed to cattle at first to the villagers in their remote areas, then when objection was raised in cattle, and then thereafter, and there is a delay, unexplained delay. Why did they not come to this court immediately 1 month, 1 year, 2 years, within maximum 3 years? There is no explanation whatsoever in the entire writ petition, my lord, except here and there they will say I have filed representation. And your lordship is conscious of the legal position that filing of representation will not extend the delay, condone the delay, sorry, delay will be extended, condone the delay, my lord. Now, next judgment which I am relying upon, my lord, in the index, if your lordship will see, Chennai Metropolitan Water Supply and Sewage Board and T.T. Murli Babu. That is 2014. This is at page 51. Judgment start at page 50. 2014. SEC. 4 SEC 108.
4 SEC 108.
Yes, my lord, and relevant paragraph is 16.
16.
Page 60, 60, my lord.
Yes.
Paragraph 16, my lord. Thus, the doctrine of delay and laches should not be lightly brushed aside. A writ court is required to weigh the explanation offered and the acceptability of the same. Court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of citizens, but simultaneously, it is to keep itself alive to the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the list at a belated stage should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, inordinate delay would only invite disaster for litigant who knock at the door of the court. Delay reflects inactivity and inaction on the part of litigant. A litigant who has forgotten the basic norms, namely procrastination, is the greatest thief of time. My lord, this line is useful for our practice also, because whenever we do something, we tend to, as a human, my lord, we procrastinate. Namely, procrastination is the greatest thief of time, and second law does not permit one to sleep and rise like a phoenix. Delay does bring in hazard and causes injury. So this is what I say, my lord, that they can't, because they have supplied, allegedly supplied, which are also shrouded in ministry, first to the villagers, and they get the utilization certificate also. All those facts, my lord, are nothing which are shrouded in mystery. All those submissions, my lord. And kindly third judgment, my lord, page 67.
On the same issue?
Same issue and one paragraph 6, my lord, at page 70.
This is 2000?
This is, my lord, this is 2006, 4 SEC 322.
322.
Yes, my lord.
Paragraph? Para 6.
Paragraph 6, my lord. In index, I have indicated, my lord, in my list judgment, the reference paragraphs also, my lord. Paragraph 6, for the convenience of this honorable court, my lord. Delay or latches. At page 70, your lordship will get it.
Yes.
Delay or latches is one of the factors which is to be borne in mind by the High Court when they exercise their discretionary power under Article 226 of the Constitution. In an appropriate case, High Court may refuse to invoke the exception if there is such negligence or omission on the part of applicant to assert his right as taken in conjunction with the lapse of time and other circumstances causes prejudice to the opposite party. Even where fundamental right is involved, the matter is still within the discretion of the court, as pointed out so and so. So, my lord, I rely on these three judgments, my lord. First judgment which I rely on the state of MP versus Nandlal Jaiswal. And then thereafter Chennai Metropolitan. All these judgments, my lord, lay down one salutary principle. That the litigant, or in case a person who is alleging that his fundamental right is violated, he has to come to the court within reasonable time. And for any reason, he can't come to this honorable court for invoking Article 226 within reasonable time. He has to explain as to why he could not come within a period of reasonable time.
Yes.
So therefore, my lord, when there is a delay on latches, my lord, the general principle which my friend has argued that limitation does not apply. I do not dispute this proposition that Limitation Act does not apply to the writ jurisdiction, my lord. But what I submit, my lord, that the principle of delay, latches, acquiescence, those are the principles which will defeat the equity, even it will take away your fundamental rights. And the laws laid down by the Honorable Supreme Court is binding on my friend and binding on me. Therefore, on this count only, and when you lordship will see the factual background in which the flood has taken place, flash flood, 30 days, relief has to be 30 days, in 90, then firstly that the relief camp was not set up, then when the objection was raised, relief camp, then they come out that relief camp was set up. All these are all disputed question of facts, my lord, where the writ code may not be required to, the parties will be required to lead evidence to prove their claim that look, I have supplied this much cattle feed of this much value during this period, I use this vehicle, I purchased from so and so shop at so and so rate, I was having money in my account, because I will get, may not, if these cases are filed, I will get the opportunity to cross-examine the witnesses. Will say, please, so how did you bring, from where did you bring all these cattle feed, and how, and lives, and then your lordship has noted that there is a livestock census required for 10 crore rupees. My lord, if I calculate the entire claim, for 10 crore rupees is being asked or being sought for providing cattle feed for 30 days or 60 days or 90 days. For how many cattle, my lord? This will feed the entire district, my lord. So therefore, what I am not saying anything, my lord. What I am saying is all these aspects, my humble submission, in my respectful submission, cannot be gone into in the writ jurisdiction. And that is why, my lord, principle I rely on the next set of judgments. Contractual nature, thus no writ, my lord. What is the claim which is being sought, my lord? Your lordship has examined that claim
Yes.
here. The claim which is being sought here, my lord, is this, that I have supplied the cattle feed as per the order placed by district animal husbandry officer, and after supply payment has not been made. So there is an order and supply and breach of contract because I have agreed to make the payment. That is what, if I take it in the plain and simple language, this is the case contractual dispute. Now, your lordship has seen that public law remedy and private law remedy are two distinct recourse available to a litigant in India. It is a private law remedy which my friend is seeking to enforce through public law remedy recourse. It is his private remedy which he could have, because state enters into the contract with the contractors, with the suppliers. And so therefore these are, in my humble submission, my lord, it is all private law remedy.
Yes.
If your lordship, on these lines, I place first judgment, my lord, that is, my lord, Radhakrishna Agarwal, and my index, my lord, at serial number 4, my lord, the judgment name and citation is there, my lord.
1977.
The 1977, 3 SCT 457
Para 17.
at 17, my lord, at page 80.
Yes.
Lordship 17 at page 80, para 17. Learned counsel contend that in the cases before us, breaches of public duty are involved. The submission made before us is that whenever a state or its agent or officer deal with the citizen, either when making a transaction or after making it, acting in exercise of powers under the terms of contract between the parties, there is a dealing between the state and the citizen which involves performance of certain legal and public duties. If we were to accept this very wide proposition, every case of breach of contract by the state or its agent or its officer would call for interference under Article 226 of the Constitution. We do not consider this to be a sound proposition in all. So if I place, my lord, if I relate to the facts situation, what is being alleged before your lordship in the writ petition, that there is a breach of contract by the officer, and the submission is that the officer breach or district animal husbandry officer or this is a public duty and therefore writ jurisdiction is maintainable. This is the plea which is being taken before your lordship, and what Honorable Supreme Court is that this is not maintainable. And the number of judgments were also cited on next paragraph only, but 19, paragraph 19 at page 81.
Yes.
We do not think that any of these cases, paragraph 18, the judgments are cited by the petitioners therein, but in paragraph 19, the Honorable Supreme Court, we do not, at page 81, we do not think that any of these cases could assist the appellant or is at all relevant. None of these cases lay down when a state or its officers purport to operate within the contractual field, and the only grievance of citizen could be that of contract between the parties is broken by the action complained of. The appropriate remedy is by way of petition under 226 of the Constitution, not an ordinary suit. I put a question, my lord, why can't they could have filed this suit? What prevented them from filing a suit against the state? There is a formidable array of authorities against any such proposition, my lord. Then the Honorable Supreme Court Now, paragraph 20, my lord.
Yes.
The Lord Solicitor General appearing for the state contended that there could be no aspect of Article 14 of the Constitution involved in case when no completion of facts or etc. My lord. So, my lord, then next judgment, my lord, is Prem Bhai Parmar at page 85, my lord.
This is citation is
This is, my lord, 1982 SCC
1980
SCC 129.
Yes. Para 8.
Para 8, my lord. And then, my lord, the principles are same, my lord. I need not burden your lordship with. Then 1981, my lord. That is at page 1981, 3 SCC 328.
3 SCC 328.
3 SCC 238, my lord. And the relevant paragraphs are 8, 9, and 10. In this judgment also, my lord.
Yes. Each
paragraph 8 at page 109. Judgment starts from 101. Relevant paragraph is at page 109, paragraph 8.
Yes.
It is undoubtedly true. I am not saying your lordship has no jurisdiction. Your lordship has wide jurisdiction. But your lordship has always exercised the jurisdiction in accordance with the settled principle of law. And that is what it is. That is what the Honorable Supreme Court also says, Mila. It is undoubtedly true that High Court can entertain in its extraordinary jurisdiction a petition to issue of any prerogative writ for any other purpose. But such writ can be sued where there is executive action unsupported by law, even in respect of cooperation, there is a denial of equality before law. As pointed out earlier, respondent was merely trying to enforce a contractual obligation. To clear the ground, let it be stated that obligation to pay royalty for timber cut and felled and removed prescribed by the relevant regulation. Validity is not challenged. Therefore, demand for royalty is unsupported. What the respondent claims is an exception that in view of certain terms of the indenture of lease, appellant is not entitled to demands. This is nothing but enforcement of term of contract of lease. So what they are asking is that there is a supply order before your lordship, and that's in terms of supply order, payment 35 rupees per, and that payment has to be made. So what is being enforced is contractual obligation on the part of the state, my lord. Hence, the question whether such contractual can be enforced by High Court in the writ jurisdiction, last line of paragraph 8.
Yes.
Ordinarily, where a breach of paragraph 9 contract is complained of, a party complaining of such breach may sue for a specific performance of contract. If contract is capable of being specifically performed, on party may sue. Such a suit would ordinarily be legal by civil court. The High Court in extraordinary jurisdiction would not entertain a petition either for specific performance or for recovering damages. Here I will say recovering money for alleged supply. If I substitute damages word with the claim, a right to relief flowing from the contract has to be claimed in a civil court where a suit for a specific performance of contract or for damages could be filed. There is so well settled that no authority is needed. This proposition is so well settled. However, we may refer to recent decision bearing the subject. Harshankar versus Deputy Excise Taxation Commissioner, petitioner offered their bids in the auction list. My lord, then this is the judgment. Then paragraph 9 I have already read, my paragraph 10, my lord. In substance, the conclusion of paragraph 10, this was a suit for refund of so and so, and that could hardly be entertained in exercise of writ jurisdiction of the High Court. So, what is the claim? You know, it's a suit for recovery of money before your lordship. Prayer is crystal clear. Direct the state government to pay 2.20 lakh rupees for a alleged supply of cattle feed to camps or outside camp, my lord. So then, my lord, kindly note Joshi Technology. This is all recent judgments, my lord. Joshi 2015 judgment also at page 113, my lord.
And all these judgments state the same. Same proposition.
See, the proposition is the same, my lord. So I will, if I need not take your lordship all in my list of index, my lord, I have given the judgments and relevant paragraphs. Your lordship may take note of this proposition of law that when there is a disputed question of fact, when there is a factual dispute, when there is a contractual enforcement of right, when there is a delay, writ is not maintainable. My colleague will place that order of your lordship. Recently, your lordship as part of division bench, where lordship has dismissed the enforcement of the writ petition on the ground that it involves disputed question of fact. My friend will read the judgment because that copy unfortunately has not come to me probably. Mr. Abraham, please please that judgment.
If I'm pleased to take your lordship to para 7 of the judgment. I'm not troubled by reading out all the judgment.
You give me 2 copies. Extra force.
Maybe he wants to give me.
Copy was for me, but unfortunately I haven't got.
For the wealth of reason indicated in the above impugned, the writ court held that the writ petition was liable to be dismissed as not maintainable. Indeed, notwithstanding the wide authority available to the Constitutional Court under Article 2 to 6 of the Constitution, there is an element of self-restraint that is exercised. Since writ proceedings are decided on affidavit, evidence, and on summary procedure, disputed question of fact which require proof are not entertained. In any event, at the end of the day, the real grievance of the petitioner is that the petitioner has been unfairly treated and has been deprived of the profit that the petitioner was entitled to upon successful completion of the work. Such grievances sound in money, and the relief that the petitioner should pursue should be by way of a suit for damage. Accordingly, WA number 22 of 2023 is dismissed without interfering with the judgment and order impugned dated 5th 2023 in view of the good reason indicated herein. However, nothing in the order impugned will prevent the writ petitioner from instituting an appropriate civil suit for damage, should the writ petitioner be so advised. This is the
My lord, the learned single judge has given the reasons that disputed question of facts and factual disputes may not be entertained in the exercise of Article 226, my lord. What I was saying is that, my lord, if your lordship is inclined to accept my submission on this point, my lord, if your lordship is also inclined to give them liberty to approach, but they have to approach in accordance with law. Because tomorrow they can't say that since the Honorable High Court has given me liberty, there is no bar of limitation on my claim. So if liberty they are entitled to in accordance with law only. That is, that they have, if they want to file a suit, the state will be free to raise the objection as to the maintainability or as claim being barred by limitation. Those are the statutory legal rights of the state which cannot be taken away, and your lordship will never take a statutory right of anyone, my lord. Your lordship, now my friend, my lord, coming back to these cases cited before your lordship by my learned friend while he was arguing the matter, my lord, he has cited 7 judgments, my lord. And if I take your lordship through those judgments, or my colleague has prepared a short notes of 2 pages, pointing out that why those judgments are not applicable to the facts of the case, my lord. If it can be placed, my lord.
Yes. The morning we could not take out the printout will be submitted during the course of the day, your lordship.
But I will have those, but no difficulty, my lord. Now, my lord, your lordship has seen the factual aspect. Now, kindly see because in both the writ petition, my lord, claim is one and the same. in the other connected matter also, my lord. Before I take, but the factual, there is hardly any difference, my lord. But kindly see the other matter in the meantime, my lord.
No, now we are jumping to the other case.
No, only for the purpose of showing what is the claim there. Only for the purpose of showing the claim, my lord.
Like you said, it's more or less similar.
Yes, my lord, the claim is that same period, flash flood. If your lordship will see the prayer, which is at page 25.
Yes.
6 crore 47 lakh for 50,000. Six crore 47 lakh 50,000. And your lordship has seen in the first writ, the claim is, my friend will correct me if I am wrong, 2 crore 20 lakh rupees for supplying cattle feed to the cattle, and the total amounts come to, my lord, 8 crore 67 lakh. And there is another supplier also, my lord, who has got some money also. My lord.
We are not concerned with him.
And we are not concerned, my lord. I am highly obliged because they have relied so much on that. So kindly see, this is a flash flood which has taken place on 22nd September 2014. The rules require that for 30 days there can be supply, my lord. The supply order also says that all these they are coming in. This Silka has come before your lordship in 21. The other one has also come in 21, my lord, after 8 years of alleged supply or 7 years of alleged supply. They are raising the contractual dispute only. The delay is unexplained. And it is the private remedy which they are trying to invoke before your lordship. It is a private remedy which they are trying to invoke before your lordship. Now, in this light, my lord, kindly see the judgments. If my colleague has given the list of books which have been relied, so that I can take your lord to those judgments.
I think we'll do one thing, Mr.
Which have been
Mr. Kaur, we'll do one thing.
Yes, my lord.
We'll continue on the next date.
Yes, please. Yes, please. Yes, please.
We can hear your reply in the next date.
My lord, I'll keep replying.
And whatever is left, you can.
Yes.
Yes.
Mr. Dev is already here.
I'm appearing in the second matter.
Yes. So, next week? Next week.
Great.
Heard Mr. E. Kumar, Leonard E.G. appearing for the respondents. The matter has been substantially heard. However, the hearing of this matter will continue on the next date fix. This is matter to 1 week.
I look.
Item number 17.
Yes, Mr.
Yeah, well, the only thing is that the amended petition that I'm supposed to file.
Have you filed?
Yeah, the only thing is that we need a signature of the divisional manager. She is out of station.
How long?
That's the only thing.
How soon can you do it?
She'll be coming by 24th. That's the only signature, because at least the signature has to be there.
So we'll list this matter on 28.
This can come up on 26 also. 26.
26. Up to you.
Or 27 also. 27.
Is the Learned Counsel for the appellant has submitted that the amended memo of appeal is ready. However, the concerned official who is to swear the affidavit could not be. It's not in station on account of his official preoccupation. Accordingly, as prayed for, list this matter on 26.
Item number 20.
Yes.
Lordship, I pray for some accommodation in this matter, Lordship. Lordship, may kindly fix this matter after 2 weeks.
Yes. On prayer made by the petitioner, list this matter after 2 weeks.
Highly obliged.
Second call, item number 5.
Please, Your Lordship. Lordship, these are those Nehu matters which Lordship 1, Your Lordship has already heard, and now it is reserved for judgment.
Yes.
So, as the understanding is that once that is decided, Your Lordship, one by one these matters will be heard.
That was what was submitted by Mr. Sen.
Lordship.
But your colleague insisted that it should be done today. So I thought,
if Your Lordship is pleased to.
it's not for me. It's not for me. It's for you.
Lordship, because since the issues are different, so if one is resolved, we start off with the next one. Otherwise, it will just overlap and get complicated.
So how long?
Lordship, as and when Your Lordship is pleased to.
I don't know.
Dispose of that first matter.
We'll list it after 3 weeks then.
Lordship.
Your Lordship, 1 week, Lordship?
3 weeks.
3 weeks.
Obliged.
Because when you say 1 week means you are very reluctant. On prayer made by parties, this is matter of 3 weeks.
Deeply approved.